Last 5 seconds. Ready? Start. Therefore, it is necessary for a proper determination of the issues at hand for an in-depth analysis of the Uttar Pradesh Kshetri Panchayat and Jila Panchayat Adhiniyam 1961 and the 1966 rules, specifically the interplay between rules 4, 7 and 12 of the 1966 rules and the legal principles enunciated by this court in the above pronouncements. It is to be observed that one of the fundamental principles of election law pertains to the maintenance of free and fair elections, ensuring the purity of elections. The principle of secrecy of the ballots is an important postulate of constitutional democracy whose aim is the achievement of this goal. The question of whether the waiver of secrecy by individual voters is allowable during the election process in the circumstances such as the present where the Uttar Pradesh Kshetriya Panchayat and Jila Panchayat Adhiniyam 1961 and the 1966 rules mandate that voting in a no confidence motion would take place by secret ballot requires detailed argumentation and analysis. Whether the same is illegal, de jure, or is allowable, or depends on the facts and circumstances of each case, taking into account the impact on the principle of free, fair, and pure elections, is a question where we find the reasoning of the High Court somewhat lacking. That said, during the course of the hearing before us, the learned senior counsel appearing for the appellant had suggested on the first day of hearing that motion against the first respondent may be put to revote or fresh voting. Accordingly, we directed the learned senior counsel for the first respondent to obtain instructions regarding the same, for which the case was adjourned. It was stated on the next date of hearing that the suggestion was acceptable on a fresh motion of no confidence being moved. The petitioners objected to the necessity to file a fresh motion as this would imply that the motion dated 1st October 2018, which was put to vote on 25th October 2018, would have to be treated as rejected, notwithstanding that 48 members out of the 51 members present, that is almost 95% of the members present, had voted in support of the motion. At the same time, the counsel for the first respondent had asserted that the first respondent enjoys support of the Jila Panchayat and is therefore confident that any motion of no confidence moved would be defeated. In the light of the above, we feel that ends of justice will be met if the motion dated 1st October 2018 is put to revote at a meeting of Jila Panchayat by way of secret ballot with the district judge Allahabad himself or his nominee additional district judge Allahabad acting as the presiding officer on a date and time to be fixed by the district judge, which shall not be later than 2 months from today. This would, in our opinion, be a just and fair direction in the actual factual matrix of the present case, given the respective contentions and stand of the parties. The appeals are accordingly disposed of in the above terms, leaving the question of law open. No order as to cost. Stop.